Great. Well, we'll call that critical mass as other people join in. Welcome to this webinar on the Supreme Court's Loper Bright decision and its impact on the coordinated framework for the regulation of biotechnology. My name is Richard Murray, and I'm the Thomas and Doris Everhart Professor of Control and Dynamical Systems in Bioengineering at Caltech, and one of the organizers of the Linde Policy Center's activities in biotechnology. Thank you for joining us today. We had well over 100 people registered for today's event, and we're looking forward to a great session. Let me first say a few words about the sponsor for today's webinar. The Linde Center for Science, Society, and Policy, LCSSP, or we just call it the Linde Policy Center, was established in 2023 and aims to serve as a national forum for research, debate, and dissemination of knowledge on topics at the intersection of science and technology. The center's mission is twofold: to advance understanding and education on contemporary science policy, and to provide data-driven guidance for policymakers and other stakeholders by leveraging Caltech's distinct scientific expertise. In the biopolicy area, we ran a workshop in February on engineered microbes for environmental release, or EMERs, that brought together researchers, technologists, policymakers, and others. In June, we issued a report with some policy recommendations coming out of that workshop, which you can find on our website. Today's webinar is our second public activity in the biopolicy area, where we're bringing together a collection of experts to talk about the potential impact of the recent Supreme Court decision on Chevron deference. If you'd like to stay in the loop for future activities, you can sign up for our Linde Center Bioscience and Biotechnology mailing list from the link on the EMER report page. A few logistics for our webinar this morning. The video and audio portions of this meeting are being recorded and will be posted on the Linde Policy Center website at a later date. You can ask questions at any time using the Q&A function in Zoom. Please note that if you ask a question today, your name may be captured and other members of the audience may wish to follow up with you after the webinar, including reporters who have registered for the event. You should feel free to like questions that have been posted to elevate them for a priority placement for posing them to the panelists, which we'll do in the second half of the webinar. I'll be monitoring the questions and passing them on to Mary Maxon, our host, to pose to the panelists as we go through all of that. But please feel free to ask them at any time. At this time, I'm pleased to formally introduce Dr. Mary Maxon, who co-organized today's webinar and will serve as our moderator. Mary earned her PhD in molecular cell biology from the University of California, Berkeley, and did postdoctoral work in genetics at UC San Francisco. Since then, Mary has worked in the private sector, both in biotechnology and the pharmaceutical industry, as well as the public sector, highlighted by her tenure as the Assistant Director for Biological Research at the White House Office of Science and Technology Policy, OSTP, in the Executive Office of the President, where she developed the National Bioeconomy Blueprint. Following her work at the White House, Mary served as the Associate Laboratory Director for Biosciences at the Lawrence Berkeley Laboratory, the national lab where the Department of Energy invests its largest share of biological research funding. Most recently, Mary served as Executive Director for the Bioscience Futures Program at Schmidt Futures, and just last week she was named as the Executive Vice President at the Carnegie Institution for Science. With her diverse and extensive background in industry, scientific foundations in both state and federal government, Mary is recognized as a national leader in science and technology policy, and it's our pleasure to have her moderate today's webinar. Mary, over to you.
Wow, that's a lot. Thank you, Richard, and welcome everyone. By now, the reminders that you've received about this webinar have given you an opportunity to learn about our panelists today. And they can be thought of as representatives of the legal and policy spheres who have specific knowledge of products of biotechnology and their regulation. Introducing you to them in order of how they will contribute today, I'll start with, run through them all, and then we'll get with the program. Keith Matthews. He's the former director of the Biopesticides and Pollution Prevention Division in the U.S. Environmental Protection Agency's Office of Pesticide Programs. He's now in private practice at Matthews Law, LLC, where he focuses on regulatory counseling related to agricultural biotechnology, chemicals, and bioengineered foods. Barbara Evans, professor of law and the Stephen C. O'Connell Chair at the University of Florida Levin College of Law. Her work focuses on data privacy and the regulation of artificial intelligence and machine learning medical software, genomic technologies, and diagnostic testing. She was a member of the National Academy's Consensus Committee that gave rise to the 2017 report named Preparing for Future Products of Biotechnology. Richard and I were both on that study with Barbara. Chris Wozniak retired from the Environmental Protection Agency in 2021 after 20 plus years and formed an LLC consulting business that following spring. At EPA, Chris worked primarily with the regulation of biopesticides, including microbial pest control agents, genetically engineered plants with pesticide properties like disease or insect resistance, and genetically engineered mosquitoes intended to reduce populations of specific vectors. And finally, Sarah Carter, principal at Science Policy Consulting LLC. For about 15 years, Sarah's focused on policy issues related to tools and capabilities for engineering biology, including biosecurity and potential for misuse, US government oversight and regulation, industry practices, and responsible innovation. Today, our legal experts, Keith and Barbara, will give us short overviews of the two important topics that will frame today's discussion: the Loper Bright Supreme Court decision itself and the coordinated framework for regulation of biotechnology. We'll hear from our panelists for about 10 minutes each after that opening contribution, and then we hope their perspectives will stimulate questions from you. And as Richard said, please feel free to start adding questions using the Q&A feature whenever. So we're going to go Loper Bright decision by Keith, then coordinated framework by Barbara. We'll have opening comments from Chris, then comments from Sarah, then comments from Keith, comments from Barbara, and then the open discussion, the Q&A. And then Richard and I will come back and do a wrap up. So Richard, thank you for wrangling the questions that we're going to use in that discussion. And with this, I would like to cede the floor to Keith to kick us off with an explanation of the Supreme Court decision that brought us all together in the first place here today. Over to you, Keith. Well, I think it looks like his microphone is unmuted, and he was working that microphone was working in the few minutes before. Yep. Richard, I don't know what you think, but maybe if he could log off and log back in, maybe we could switch the order of the two introductory
Sounds good.
presentations and ask Barbara to step in with the coordinated framework.
Yes, I would be happy to do that. I was asked to say a few words just to make sure everybody is familiar with what the coordinated framework is. This is the coordinated framework for regulation of biotechnology, and it flowed out of the 1980s, which was a time when there was a great deal of concern that recombinant DNA research and technology might pose catastrophic risks that needed careful regulatory oversight. And at that time, some nations were going the pathway of doing general biotechnology new legislation. And that was considered as a possibility here in the United States. But what was decided instead, a White House working group on biotechnology proposed the idea that rather than create a whole new statute and new legislation and create a new agency, what we could do in the United States would be to have a coordinated framework that would task the existing regulatory agencies we have, such as the Food and Drug Administration, the Environmental Protection Agency, the Department of Agriculture, and all the many regulators we already have, and ask them to regulate new biotechnologies as they emerge using the statutory or congressionally bestowed powers that they already had. For example, FDA would regulate under the Food, Drug, and Cosmetic Act. EPA could regulate under its existing authority to regulate pesticides and toxic substances and so forth. This approach is actually one of two major approaches that I've mentioned. You can either do a whole new legislation, or you can use the statutes you have and the agencies you have. And the coordinated framework approach is very favored in modern times. The United States has been reluctant to create whole new regulatory bureaucracies since the 1970s. We have plenty of them and like to utilize them. Often with new biotechnologies, there are shortages of personnel who have expertise of that technology, so that it's hard even to staff the industry, much less have a whole additional staffing of regulatory agencies. And then the main thing that drives this decision is speed. quite often when you have a new and poorly understood type of technology, there's a lot of hype, and people are very concerned that we don't understand the risk and it may be catastrophic risk and we need to do something quickly. We've seen this more recently with all of the efforts to regulate AI technology. And when you have this notion of this could be very dangerous, you want to move quickly. And a coordinated framework approach lets you use existing agencies and they can go right to work and it's fast. The problem is that you can question whether that's the optimal approach because the old statutes they use may have some gaps that they have difficulty working with or may just not be perfectly aligned with the technology that they're trying to regulate. But fortunately, and this is the linkage to what we're going to talk about today, the issue of deference and the Loper Bright decision, such an approach requires that agencies be able to interpret existing statutes and apply them in new ways. So a coordinated framework approach relies heavily on the regulatory agencies to be able to be nimble and interpret that, okay, is this thing more like a drug or more like a device, or is this more like a pesticide, or so that they can slot new technologies into the framework. So the issue of how much deference these agency interpretations receive becomes important in implementing a contraption like the coordinated framework. I'll note, however, that the other major approach of passing whole new legislations has that same feature, because if you want to quickly make a new regulatory framework for a technology that we don't quite know yet what it's going to be, whether it's Congress or Parliament in the UK have to be very general with that legislation. They have to say things like, please, make this safe, make this effective, make this reasonable. And then you still need an agency in there interpreting what that means. So no matter what approach you take to regulating these advanced and emerging technologies in real time, it calls upon a regulatory agency to be nimbly interpreting how does this apply in this situation. That's why the Loper Bright decision has raised a lot of concern of how will that be affected. Now, do we have Keith back?
We do, and we're going to do a mic check.
Okay.
Yes, I am here, and Barbara,
Fantastic.
I am very pleased to say I can hear you. I don't know. I apologize, everyone. My audio just switched to another setting, and then I heard nothing. So I hope you can hear me.
We can hear you.
Okay. My sincere apologies, Richard.
No problem. So Barbara, that's probably a good spot to transfer over to Keith then. Great. So Keith, your slides are up, and go ahead.
Okay, perfect. I'm going to give a
Thanks.
very, very brief summary and talk on judicial deference and what the Loper Bright case was all about. Judicial deference is actually a concept that has been in the law for many, many years. An early case that actually dealt with judicial deference was Edwards-Lessee v. Darby. So what the court said, and you see this is an 1827 opinion, so what the court said was that in the construction of a doubtful and ambiguous law, so the concept of ambiguity in the law was something that people were thinking about even as early as in the 19th century. Contemporaneous construction of those who are called upon to act under the law is entitled to very great respect. And so we can go to the next one. So in the context of judicial deference, there are three types of agency actions that have been addressed by the court. One is where we're talking about agency guidance or policy statements. Another is where we're talking about agency interpretation of statutes. And then the third would be where we're talking about agency interpretation of regulations. And so one very, very important case, and Barbara's going to talk about this, I think, to some extent, is Skidmore. And so Skidmore was a 1940s case. in which the court considered rulings, interpretations, and opinions of the particular administrators. It wasn't the administrator of EPA at that time, it was another agency. And so this is guidance. And so what the court said was that while the rulings, interpretations, opinions of the administrative agency are not controlling upon the courts, they do constitute a body of experience and informed judgments to which courts and litigants may properly resort to. And if you look at it, then what is the weight that is given to such statements by an agency depends upon the facts that the case that the court reviews and how the agency conducted that or issued that particular policy. So we go on to the next slide. This actually concerns the Chevron case. And so Chevron, so we start with the very familiar Chevron two-step. If a statute, and Chevron deals with statutory interpretation. So if a statute is unambiguous, then the agency, as well as the courts, have to give effect to the unambiguously expressed intent of Congress. Well, what if a statute is ambiguous, as most are? Or if it's silent with respect to a specific issue? Well, what the Chevron case said, and I will note that this, of course, was an opinion by Justice Scalia for a 6-member court at the time. 3 of the justices recused themselves from the Chevron case. So if Congress has explicitly left the gap for the agency to fill, there's an express delegation of authority to the agency, but sometimes the gap is implicit and is not explicit. And in that case, very, very interesting language. In such a case, a court may not substitute its own construction of a statutory provision for a reasonable interpretation made by the administrator of an agency. So what the court is saying there is that the agency's interpretation of an implicitly ambiguous statute will control. And we go to the next slide. No, that's, I think we skipped a couple there. Back one more, maybe. Okay, all right, this is good, thank you. And so that's Chevron. And then in the case of a ambiguous regulation, you have Auer versus Robbins. So this is Auer deference. And so what the Auer court said was that a federal court must defer to an agency's interpretation of ambiguous regulation, unless the court finds that the interpretation is plainly erroneous or inconsistent with the regulation. So very much consistent with the Chevron case. Okay, so the next slide. And so now we get into the actual Loper Bright case itself. And so Loper Bright involved an ambiguous regulation. In fact, statute. The statute, in fact, was explicit in some respects and left an implicitly ambiguous in another respect, which was the subject of the case. And so the agency made a particular determination by regulation. The regulated party, or some of the regulated parties, sued. Federal Court of Appeals basically said, we view the statute to be ambiguous. We view the agency's interpretation of the statute and this regulation to be reasonable. The interpretation of the statute is a reasonable construction of the statute. The regulation is reasonable. Therefore, under Chevron, we defer. So what the Chief Justice in Loper Bright, and of course, Loper Bright overturned Chevron explicitly, he looked at the case from the standpoint of the Administrative Procedure Act and stated that the APA requires that courts exercise independent judgment in determining whether an agency has acted within its statutory authority. Familiar Section 10 of the APA requires courts to overturn agency actions that are arbitrary, capricious, or not in accordance with law. Next slide, Richard. And so there was a lot to unpack in that case. And so he goes all the way back to say that the framers of the Constitution intended that final interpretation of the laws would be the proper and peculiar province of the court. respect, obviously, is to be given to the interpretations of the executive, but that is not to control. In cases where a court's own judgment differed from that of other high functionaries, the court was not at liberty to surrender or waive it. Next slide. And so very explicitly, the Chief Justice stated the deference that Chevron requires, and I note, I think it's very important to note that the Chevron case required that a reviewing court, defer to an agency that it determined if that agency's interpretation of an ambiguous statute was reasonable. And the deference that Chevron requires of courts cannot be squared with the APA. And we can go to the next slide, Richard. And so it said, neither Chevron nor any subsequent decision of the court attempted to reconcile its framework with the explicit language of Section 10 of the APA. It requires a court to ignore, not follow the reading the court would have reached, and it therefore makes no sense to speak of a permissible interpretation that is not the one the court, after the court itself, after applying all relevant interpretive tools, concludes is best. So then if we can go to the next one. Oh, and this is another slide. As I said, there was a lot to unpack there. So, and this kind of, the very last paragraph there, I think, is something that we might come back to, that neither a desire for uniform construction of federal law justifies Chevron. It's unclear how much, and also it's unclear how much the Chevron doctrine as a whole actually promotes such uniformity. And I think Barbara's going to talk a little bit about that. Okay, and I think the next slide should be, let's go to the next one. That's going to talk about the dissent. So Justice Kagan had a very, very strongly worded dissent. And she accused the court of ignoring stare decisis, said that the court has long understood that Chevron deference reflects what Congress would want, and that it, in fact, was rooted in a presumption of legislative intent. I note the third paragraph here, which, very strongly worded, said, if the opinions had a title, a good candidate for today's would be hubris squared, which I actually find kind of humorous. And there was a bit of a back and forth with Justice Kagan and Justice Gorsuch on stare decisis. And I will make one last point, which is that in his concurring opinion, Justice Thomas also pointed out, even though the Chief Justice had rooted his opinion in Section 10 of the APA, saying that Chevron was inconsistent with that statute, Justice Thomas noted that, in his opinion, Chevron is also inconsistent with the principle of the balance of powers among the branches of the government. And so therefore it was an intrusion upon the powers of the court, the Article 3 courts. And Richard, I think that's my last slide.
Yes, it is.
Okay, so I'll stop there.
Terrific. Thank you, Keith. And glad we were able to bring you back on there. And thank you, Barbara, for the explanation of the coordinated framework. So we've got these two important elements of our conversation today explained. And now we're going to turn to Chris Wozniak to figure out, what does this all mean? Over to you, Chris.
Thank you, Mary. I appreciate that. As Mary mentioned a little bit ago when she was introducing the panel, she said that I worked for EPA for 20 plus years. And before that, I had 10 years with the Ag Research Service at USDA and 4 years in another grant funding agency at USDA as well. The one degree, though, that I never finished up on besides the biochem, the plant pathology, was one in clairvoyance and soothsaying. And I think that's really what's needed here. I want you to take everything I say pretty much with a grain of salt, in the sense that on in this game, so to speak. It was end of June when the Chevron deference basically, in my opinion, was abandoned. And we just don't know yet how things are going to turn out. I'll give a couple of examples that give us a little insight. But quite honestly, at this point in time, I think things are, all over the board. I'll share first a few of my concerns, again, coming from a regulator's perspective, not a legal perspective per se, as a judge or attorney. But one of the things that I learned as a regulator is that predictability is key. When people who are developing products or people who are going to purchase those products see that there's a lack of predictability in that regulatory system, it raises a lot of issues. Uncertainty is your enemy as a regulator. And so I think that's exactly what this decision did in June, because now we see things. There was just a recent court case on ghost guns. Well, I think the vast majority of Americans would say, well, of course somebody's got to regulate ghost guns or make them or whatever you need in this, and get in ATF's way, in my opinion. And so, fortunately, that seems to have turned out well. But there's another case pending with PFOA and PFAS compounds, where for the first time, the EPA under CERCLA, basically the Superfund statute, has come out and called these hazardous substances as opposed to contaminants or pollutants. Well, it sounds like word salad, but it really makes a big difference. As a hazardous substance, the responsible party, typically the manufacturer, is responsible for cleanup. And as you can imagine, environmental cleanup is immensely costly. So already there's a challenge to this from the industry folks. And with the lack of Chevron deference, they're already questioning, is that interpretation by EPA erroneous? In other words, did they just get it wrong? So these are the kinds of things that we're messing with here. This is really the monkey wrench in the printing press, in my opinion. And I don't want to hazard a guess, at least I'm not a betting man, but I can tell you a couple things that I do feel fairly certain on. One is that someone mentioned rulemaking earlier. Rulemaking, basically taking the statute you're given and it extends authority to you as an agency to develop written regulations to cover something, whether it's a microbial pesticide or a chemical under TSC or Toxic Substances Control Act, something like that. And, people rely on various definitions and things in there, and you only get that through this laborious process known as rulemaking. Agencies are not going to put out the resources, meaning a whole bunch of people, 8, 10, 15 people, whatever it takes, to sit down. And this can take literally, I've been out for 5 years to write a rule. This does not happen overnight. If at the end, you're still thinking, well, Supreme Court could turn around and just say that this is all wrong. You just got it wrong. And you don't have, as Justice Roberts said, one of my favorite quotes from him, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. If that isn't the epitome of arrogance, in my opinion, it's insulting to scientists. And Keith was one of them, but there's a whole boatload of legal scholars at these executive agencies as well. And to say that they just don't have the competence, that are spending most of their career on 1 or 2 statutes and focusing on, outcomes. So with that, I won't go into. I have a couple other things to say about asbestos and things like that are also, sort of in the air, so to speak. There's lots of juggling going on, but just to say that even things like climate change are now being questioned. Mercury, methane emissions. Those are going up, those new rules. And a lot of people in the industry feel like this is their time to basically tell EPA thanks, but no thanks. And remember, EPA is loved just as much as IRS. So with that, I'll pass the baton.
Thank you, Chris. That's thank you for kicking us off and trying to get to what is the impact of the Loper Bright decision on regulation. And so let's hear from you, Sarah. What do you think?
Yeah, so there's, well, first of all, let me just say I am also not a lawyer. I'm a scientist. I've been focusing on policy issues related to to advance biotechnologies for many years now, including the coordinated framework. Thanks for hosting this event. I think it's really important, and also thanks to Barbara and Keith for providing some of the more legal basics for this discussion. Barbara mentioned a little bit about the coordinated framework, and she talked about, kind of by design, the coordinated framework is full of stretches of different statutes. And this is why we're here, why we worry that Loper Bright could have an impact on this framework. But there's so many different places where Congress definitely didn't have these applications of the statute in mind when they passed those laws, decades before the rules, came out. These are, some of the things that we've talked about for many years, plant pests that are actually transgenes with tiny fragments of an agrobacterial genome, or chemicals that are actually intergeneric microbes, pesticides that are genetically incorporated into the plant as plant incorporated protectants. Pesticides that are actually genetically engineered mosquitoes, animal drugs that are actually transgenes or intentional genomic alterations, and a little bit, broader, or, a drug manufacturing facility that depends on plants or animals to produce the drug. And these are all things that sort of like the community here, many of the webinar attendees, I saw a lot of familiar names there. We've gotten used to these things. We've gotten used to thinking about these products and these applications of the statute in these broad, abstract ways and through these analogies. And all of these were interpretations by the agencies, as Barbara mentioned, to slot things in, new technologies into their existing regulations. In my opinion, that makes the coordinated framework an amazing body of policy that has grown and evolved in different directions over the years since 1986. So one of my first sort of points for this discussion, and it's kind of a question for the lawyers, and I hope that Keith will get to it in the discussion, is, to what extent are these interpretations that have already been made legally settled and therefore not subject to revisiting or reopening? I'm not a lawyer, but I fear that the landscape might be very nuanced with a lot of different legal decisions that have weighed in bits and pieces and in different parts of the statutes. And that's something I don't know about, but I would love to hear sort of more legal analysis about what we can expect and to what extent the coordinated framework as it exists today will be subject to that kind of, the legal challenges. My second point is the effect on Congress. So there's, as Keith mentioned, all of this applies, all of the whole agency deference and how much and all of those legal decisions all apply because of ambiguities in the statute. And I think that Congress, because of this, because of Loper Bright, Congress could be under some pressure to reduce ambiguity in the regulation of biotech, and that will be extremely challenging for Congress to do anything in this space. And ever since I've been paying attention to these topics, I've never known anybody to say, "Oh, good, let's let Congress take a swing at it," because nobody expects anything good to come of that. And there's some good reasons for that. First, there are just practical matters. Congress will need to increase their resources and staffing to understand these issues, and they can do that in a variety of ways, but they currently do not have that kind of capability. There's challenges just because it's biology and biotechnology. No statute can be perfectly precise, particularly with the rapidly advancing capabilities like in biotechnology. Horizon scanning in particular is very difficult to do. It'd be very difficult to have reasonable statutes like that. To me, the coordinated framework poses particular challenges, which, it raises particularly tricky things. One is that biology and biotech touches everything. This is how we ended up with the coordinated framework to begin with. The different parts of biotechnology applications fall under different purviews, and the same is true in Congress. They fall under different congressional committees. They fall under different kinds of areas of attention of different Congress people, and coordination will be just as big a problem there as it has been for the agencies, perhaps more so. And they would be subject to all the same forces and all the same challenges that the current coordinated framework is as well. The other problem with having anything to do with Congress is that it would open questions about articulating the risks. The what are we worried about has always been a huge challenge for the regulation of biotech. Among the public and among Congress, you would get very quickly, I believe, to non-scientific issues of ethics and economics, and they're all over the map and that are very thorny and are not always science-based. Our current system, works pretty well, in large part because the statutes are designed to protect against particular risks, and they're very science-based. And it's not clear what happens if we reopen the discussion about biotech regulation in the context of Congress. So I don't know, if in the long run, this kind of decision-making will put that kind of pressure on Congress, but I expect that there will be more conversations along those lines than I've seen in the past, 15 years or so. The third point and last point that I will make is just that, that we get, Chevron deference applied when there's ambiguity in the statute on a precise point. And we get that a lot in bio and biotech, even beyond the coordinated framework. And so there are sort of broader implications and also kind of lessons learned and things that will come together and have different, will sort of give different texture to these different questions. For example, I know that there's discussions in Congress now on biosecurity and preventing misuse of synthetic DNA. There's different discussions about working towards a regulatory framework for providers of synthetic DNA to ensure it's not misused to cause harm. And there's challenges there about how precise and how ambiguous that statute can be. There's also a lot of discussion about AI regulation and what that should look like. And I've been really sort of tickled to hear that there's all these discussions about the regulation by each agency according to their existing statutes. To me, this sounds like a coordinated framework for AI. Which would be very interesting to compare, and not just in a sort of a abstract comparison. Some of those regulatory frameworks would be at the intersection of AI and bio, and I think that there's going to be some interesting work that's going to be happening in those spaces as well. And I'll just be really interested in the near future to look at some of the legal precedents that will be generated in this new post-Chevron era, and how those sorts of lawsuits that come up in those other contexts will be applied or will be relevant to the coordinated framework. So that's something that I'll be tracking over the next few years. But I think I will leave it at that and move along to our more legally informed panelists to hear their thoughts.
Thank you, Sarah. A coordinated framework for AI. Wow, here we go. Okay, and with that, thank you. We're going to move to Keith. Please share with us your perspectives on the impact of Loper Bright on biotechnology regulation.
Yeah, thank you very much, Mary. I'm happy to do that. And I see we're just about on schedule here, so I will definitely keep us on, make sure my remarks keep us to our time limit. Richard, I wonder, would it be possible for you to pull up my penultimate slide again? I actually rushed through that, and there was a point that I really wanted to make, which Sarah reminded me of. So I would like to make that point before I kind of embark on some more general thoughts. Is that possible?
Is that the one, Keith?
Yes. And so the last paragraph there, and Sarah, thank you for asking that question, because this is something I really did want to point out, but I was kind of rushing through these things and I missed the last two. The one is italicized. I'll leave that. That's just a statement of the Chief Justice, which I'll leave it to other people to interpret that as best they see. But with respect to your specific question, the Chief Justice did speak to the issue of, so what does this mean for existing regulations, for interpretations of statutes that have occurred prior to Loper Bright, for which a court may have deferred to the agency and felt that they were compelled to defer to the agency. And so what the Chief Justice said was, the court does not call into question prior cases that relied on the Chevron framework. Thank goodness. That would have been just an absolute disaster and complete and total chaos. The holdings of those cases that specify agency actions are lawful are still subject to statutory stare decisis, such as that is. despite the court's change in interpretive methodology. So, Richard, that's all I wanted to show. So that actually gets to the point. So we don't have that potential for utter chaos where every regulation that may have been upheld in the past under Chevron, to the extent that it was still subject to a court's reviewing jurisdiction, could be called into question because of a prior court's reliance on Chevron. And so it's kind of jumping into my general remarks. So as I indicated during my introductory talk, so the thing about Chevron is that it compelled a court to defer to an agency interpretation of an ambiguous statute if the court did not determine that the agency's interpretation of that statute was clearly erroneous. And my own opinion is that that's problematic. I mean, courts should not be compelled to defer to agencies. That's just not how our system works. The Skidmore standard, which I think, in fact, and I'm curious to hear what Barbara will have to say about this, I think that Skidmore now will become more widely applicable and will not just apply to, or the Skidmore approach will not just apply to agency guidance and policy statements, but also to regulations now. I will note that Chris's comments put him, I think, squarely in the camp of Justice Kagan, and I agree with both of them, quite frankly. From the standpoint, I was thinking about this last night on a very late night walk with my dog, that, exactly what Chris said. There are attorneys that I work with in EPA, OGC, who spent their entire careers working on specific statutory provisions. There is no one, and I feel confident in saying that there's no one, anywhere who would know the history, the intent, the implementation history, the judicial review history of particular provisions of statutes than those attorneys. That's what they spent their career, almost in some cases, all their careers on. Are they better able? Are they better capable? Are they more, would it be more appropriate to defer to their interpretation of a statute and how that statute should be implemented? As a matter of policy, that may in fact be the case because these people are experts. And probably it's fair to say they're more experts than a judge who may have just come across or been confronted with interpreting this particular statutory provision in the context of a specific case. But regardless of as a policy matter, whether or not that would be a preferable approach, I don't think that comports with our Constitution. I agree with the Chief Justice. I don't think it comports with with Section 10 of the Administrative Procedure Act. Judges decide questions of law. They can be influenced. They can be informed. They can look to agency action and agency briefs and explanations for guidance. But for them to be compelled, I just don't know that really does comport with the way that our system is supposed to work. And so I think that's going to be just one more point. I do believe that the fact now, however, that Chevron has gone by the wayside in the past, and I think Barbara may disagree with this to some extent, and I'm curious to hear what she has to say about this, but I think that in the past, Chevron has acted as a brake on some judges in terms of making decisions as to whether or not an agency has acceptably or has interpreted a statute in an acceptable manner. Now with that gone, I think that, we may have basically the wild, wild west out there. And I question whether there's any agency regulation that, if challenged, won't be overturned by some judge somewhere. And I'll stop right there.
Thank you, Keith. Well, Barbara, the gauntlet has been tossed over to you. So let's hear it. What do you think?
Well, Thank you very much. I agree. This was a very timely topic for a webinar. I want to explain why I feel optimistic that the impact of Loper Bright is not going to be as profound or as harmful as it sometimes has been portrayed in public discourse and in the press. Specifically, it's been portrayed that the Loper Bright decision is going to undermine the regulatory state and is going to favor intensely anti-regulatory agenda. And I don't agree with that. I have been impressed over my lifetime as an attorney what a great job the press does in taking really complex legal issues and explaining them in a way that the public can understand and engage with them. But on this Loper Bright decision, I think much of the coverage may have misstated what Chevron was and what the impacts will be of overturning it. And I think that's excusable because if the public commentators have been confused about this, judges have got it wrong for the last 40 years, sometimes in attempting to apply Chevron. It's a complicated issue. So I want to make 4 points here. My first point is to understand that Chevron and the Loper Bright decision deal with a procedural issue. That is the decision of who should get the benefit of a doubt when making decisions about statutory interpretation, but they don't have any substantive content. They don't say you have to decide it liberally or conservatively. It's purely procedural. And I think that point is pounded home that the Chevron case in 1984 supported an administrative agency, the EPA, in a decision, this was during the Reagan era, to sort of take a pro-industry posture in enforcing 1970s National Environmental Protection Act. So in that context, it was kind of went for lighter regulation by deferring to the agency, whereas now it might go the other way in terms of the substance. Whether you agree with Chevron deference or not, in terms of what it does, in terms of the substantive policies, will depend on whether you currently agree with the executive branch agencies or not. And it will go either way depending on who's in charge. So it doesn't have any substantive bias to it. It's a procedural thing. My second point is that when you really look at the reality of how Chevron deference has been applied since 1984, one view of the Loper Bright decision is that it has merely aligned what the doctrine is with what judges were actually doing. There was a marvelous empirical study in 2008 by two of our nation's leading legal scholars, William Eskridge and Lauren Baer, and they looked at over 1,000 cases that were decided after Chevron in the federal courts. And what they found was that at the Supreme Court level, when the Supreme Court was reviewing agency interpretations of their statutes, only 8% of the cases actually followed Chevron. And in 53%, or a majority, it appeared that the judges were making their own interpretation of the statute and sort of going with that. There was a much more complex continuum of deference that was being accorded. For example, in national security cases, courts were very deferential to agencies. In cases that involved important rights, such as constitutional rights or the rights of criminal defendants, courts were very skeptical of agency interpretations and saw their job as to protect the Constitution. And then in the vast middle, where most EPA, FDA, biotech type decisions were, it varied. And a lot of the decisions looked like what Keith has described, the Skidmore deference, where you look at factors like, did this agency clearly have authority to make this decision? Does this decision depend on the agency's special scientific or technical expertise? If so, courts tend to defer to it. And in another particularly important factor is this decision consistent with the history of agency policy? Courts would be more skeptical if an agency suddenly came out with something that just flipped its previous decisions on their head. So it's important to understand that the myth that Chevron compelled courts to defer to agencies was not really happening in practice. Courts were doing this in a much more nuanced way and looking at a lot more factors than Chevron deference seemed to allow. My third point is to understand that the Chevron deference only really applied when an agency acts through notice and comment rulemaking. And Chris Wozniak described this. This is the very complicated process of making a regulation and getting public comments, and it can take 5 to 10 years in some cases to complete. Well, the fact in biotechnology is that these technologies are evolving really rapidly, and sometimes there just isn't time to go through that process of making regulations. And for this reason, agencies often rely on guidance documents to set policy. And guidance documents were never entitled to Chevron deference in the first place. So for the vast swath of policies that are set through means other than notice and comment rulemaking, the Loper Bright decision doesn't change anything. It was Skidmore deference before Loper Bright, and it's Skidmore deference afterwards. So there won't be a profound impact. And finally, the Skidmore framework, which Keith described, is a pretty good framework. Courts still give a very large amount of deference to federal agencies under Skidmore, but they look at, did the agency give a very thorough analysis of the problem? You know, how thoroughly did the agency consider the problem? Does the agency interpretation seem to be valid scientifically and legally? Is it consistent with the agency's earlier policy? And if an agency explains all that in a way that's persuasive, their decision will get deference under the Skidmore framework. And I think it actually creates a very good incentive to hold our agencies to that standard of being thorough in their analysis, checking the validity of their analysis, and communicating it really clearly so that it will persuade. It's a good incentive structure, in my view, to hold agencies to that as they make policy. Thank you.
Thanks, Barbara. Thanks, everybody, for their introductory commentary. I know that there are some questions that have been coming in. And before we get to that, I'm just going to remind everybody that we've got 80 plus people on this line, and there's some people who have very different ranges of backgrounds. And so feel free to ask your questions and try to be as clear as you can in putting them out there. This meeting is being recorded, and your name will be recorded as well if you ask a question. Use that Q&A function. You can specify a question directly to a panelist if you want to. And as Richard noticed us earlier, feel free to like questions to push them up into the priority list to be asked. Anonymous questions are not enabled. So if you ask a question, your name may be captured, and other members of the audience may follow up with you, including any media that we know has registered for the event. And so
just a quick thing, Mary, just to let people know, it's true that we're recording your name on these. We're not going to broadcast that information, so only the video and audio will be put out on the website. So don't worry about your question coming up that way, but people can see it. Obviously, everybody participating today can see it over on the side.
Thank you, Richard. And so what do you think, Richard? How are the questions shaping up? What do you think?
It's good. And maybe I'll, put one in here, just there are a couple of questions around corner post and talking about, whether or not that might open the door to challenges of decades old regulations. And another one, kind of related to that is, might a new entity be formed that might challenge the coordinated framework? So maybe somebody can first, maybe Barbara, you can say a little, you probably know what corner post is. Maybe you can say a little about what corner post is as a decision, or Keith. And then maybe, what do you think? Will that affect the way that decades-old regulations have been set up? And might a new organization, kind of be put into place specifically to challenge the coordinated framework?
I'm going to defer to Keith on that one. That's not an issue I have particularly focused on.
Okay, Keith.
I'm going to answer it from the standpoint of the coordinated framework, and because I think Sarah gave a really had a really good discussion of the coordinated framework, how it came about, and its importance. And the one thing that really has concerned me is that, and this is a point that Barbara made with respect to the standpoint of decision making and rulemaking. So when technology moves as fast as it does, and let's face it, molecular biology, the technology of molecular biology and biotechnology is moving faster than Lewis Hamilton in a Formula One car. I mean, it's just incredible what is you have this a tremendous and just an incredible advance in molecular biological techniques. And 5 years later, it's, we've moved on. Our scientists have moved on to something new and something better and something greater. And the regulatory agencies just simply cannot keep up, certainly not from the standpoint of regulations. And so it does concern me that the implication of the case seems to be that if we will give greater credence to decisions and interpretations of law that are conducted in the context of APA rulemaking that are actual regulations. And so that's just something that's just going to be completely unworkable in the technological world that we live in. Now, with respect to how might this case impact the coordinated framework? Well, it's interesting because we have 3 different agencies that regulate on the basis of different statutes, 5 or 6 different statutes. The statutes have different statutory standards. The agencies have different statutory missions. So is it possible that USDA could issue a decision under the Plant Protection Act that then gets challenged by opponents of biotechnology? I think that is certainly the case. And what I would hope in that context is that the court would look at that decision from the standpoint of Skidmore deference and give deference to the agency's determination if, in fact, it was based upon a reasonable evaluation of the relevant facts. It's really going to be, we're really just going to have to wait and see what happens. I agree with Chris that I really don't like to get into the business of prognostication. It's very difficult. I'm usually wrong. And so it's the sort of thing we'll just have to see. But there is some concern there because, as I indicated in my earlier remarks, I do think that there's the potential for judicial activism here that I think may have been unleashed a bit more through Loper Bright. Yeah, I hope that answered the question.
Thanks, Keith. It looks like we have another question that looks like it's got a bunch of votes there. 4 votes for
corner post.
Okay.
There's one at the top. And I think, Keith kind of addressed a lot of that in terms of whether or not there might be a challenge to the coordinated framework. I don't know whether Barbara had something she wanted to add. No. Any others? Sarah or Chris?
Yeah, I just opine. Something Sarah said, I guess, triggered this in my brain. I'm not sure why. But when you look at individual statutes, whether Keith just mentioned Plant Protection Act, relies on something being defined as a pest in order to be sort of under that authority. In FIFRA, pesticide law, the EPA, someone pointed out to me not too long ago, and I believe this might be something we'll see now that Chevron deference is no longer there. The definition of a pesticide talks about substances and mixtures of substances. And one of the main arguments, and these were people on my PhD committee when I first started, EPA published a paper and basically said EPA has no authority, legally speaking, to regulate. At the time, they called them plant pesticides, but then they became known as plant incorporated protectants. And the idea being that engineering something into a plant, it's no longer a substance. Or having a microbe, a bacterium, a fungus, or a virus that you're using to control a plant disease or an insect pest. That's not a substance, that's an organism. And I wouldn't be shocked at all if somebody in industry, I mean, there already are movements I won't go into where people are trying to escape the grasp of FIFRA using microbes, some of them genetically engineered. And so I'll be surprised within the next year if we don't see a legal challenge to all of that and people basically selling and distributing without the registration process.
Okay, thank you, Chris. Richard, what do you think? What's up next?
You want to pick one of the ones that we also have a couple of questions on our end, Mary? You want to try one of those?
Yeah, sure. I'm actually interested. I'm going to fire one over to you, Sarah. You made a point earlier that nobody wants Congress to get involved in this kind of thing because, well, it requires a lot of extra staffing and time, et cetera. But turning to the courts, where do you think the courts will get the expertise they need to determine if an interpretation is reasonable?
Yeah, I mean, somebody already mentioned about how like there isn't a lot of expertise in these topics, and you know there and certainly as it intersects with the legal system, and I think that you know it's going to be hard to come by. I know that both, I think all three of the other panelists made the points that the agencies have a lot of this expertise. And it's, you know, in-house, but also with their advisory committees. You know, many of the community outside of the federal government that does have this type of expertise are regularly drawn on by the agencies and advisory committees, you know, and other kinds of external, you know, stakeholder, you know, sorts of engagements. And to do it right, I would hope that the courts, in an ideal world, would draw on some of those same, you know, people and that same type of expertise. I don't know what that looks like. You know, I don't know, you know, what, how the courts would even have access or know to get access to, you know, to those, you know, kinds of people. And I don't, one thing that I am pretty certain is that the courts will also, you know, I don't see any part of a court system that does horizon scanning. And to me, that would be, you know, a really interesting looking process. But I mean, the short answer is I feel like I know where they could get that expertise, but really it would be from the agencies and from all the advisory committees and things that the agencies draw on. And perhaps that would just look like, you know, Skidmore deference or, you know, some of these other differential, you know, processes, but just couched in different terms. But yeah, I would, people that know courts better should weigh in here.
Well, it looks like Barbara is itching to jump in here.
Yes, thank you. I was impressed as I reread Loper Bright last night just to refresh my memory of it, how throughout that decision, the court is so clear that before Chevron, during the time of the Chevron, and afterward, courts fully expect that they will defer usually to an agency on issues of science or economics or how to set a pension or whatever the technical issue is that is within the agency's expertise. Courts have never second-guessed the technical expertise of agencies unless what the agency did met the standard of abuse of discretion or was just like clearly against the evidence. So that has been the case, and it will continue to be the case. We're not going to see judges, who were political science majors and went to law school jumping in and determining, is this drug safe? Is this that's the agency's expertise. All they were trying to deal with was when you have a decision that involves interpreting a legal point in the statute. And I very much agree with what Chris said, that many agencies have good in-house counsel and access to good counsel, and they become very expert in understanding the statutes that govern what they do. Nevertheless, there are sometimes issues where an agency is asked to interpret its own jurisdiction, whether it has the power or not to regulate a thing. And at those points, it's really, setting an agency's jurisdiction is something that Congress and the courts in the first instance do. And those are the points at which I think this decision is clarifying what courts were already doing. Even under Chevron, courts were reluctant to defer to agencies on those sorts of issues. And Loper Bright just brought it into conformity with current practice. The second point, and I'll make it briefly, is courts are always in this situation of trying to wield issues that do turn on scientific truth. We see it in tort and injury cases so often, that they really turn on scientific facts, and they are able to do it. Each side brings its experts, and the experts testify, and they contradict each other. And if necessary, a federal court can appoint a special master to look into an issue. So I don't think that's something that courts are going to have a problem with. They know their limitations. They know they aren't scientists, and they have ways they've always managed it and will continue to do so.
Fantastic. I guess that's an answer to the question, where could courts get that expertise if not the agencies? Before we go to another question, it looks like Keith is ready to intervene.
Yeah, well, not intervene, just kind of add to the discussion a bit. I raised my hand just to kind of respond a bit to what Sarah was saying, but I also, with respect to Barbara's last comments, my concern, as I expressed earlier, is that we're going to enter into a period of greater judicial activism where certain judges, not courts in general, but then of course it doesn't have to be courts in general, it can be an individual judge, can just kind of take it upon themselves to issue a decision that is either not founded in the facts or in the law. And I think in particular the mifepristone case, where a district judge in Texas decided to take it upon themselves to overturn a FDA regulatory determination that had existed for decades. So that is my concern, that may in fact become more, that sort of activism may become more prevalent. And with respect to what Sarah was talking about in terms of courts and their expertise, now I'm not speaking about here a case that involved federal regulations, but if I paid a lot of attention to the Roundup cases, particularly the ones in the Northern District of California. And I was very disappointed that the judge in that case did not, in my opinion, exercise his authority appropriately with respect to the admission of some expert testimony, which I view as somewhat questionable, and let issues of fact go to the jury that I think were insufficiently supported by the evidence that was presented, by the expert witness evidence that was presented, and also that I questioned seriously whether or not the jury was capable of even addressing the very technical issues that were present. And so that kind of, from my thinking, gets to the point of how are the courts going to really address these extraordinarily technologically complex issues, and where are they going to get that expertise? It would be great if in a perfect world, every judge availed themselves of Skidmore of the opportunity to listen and hear from the experts in the agencies and to apply Skidmore and a Skidmore approach. I just worry that there may be a fair number who don't.
Thank you, Keith. Sounds like a lot of concerns around where our court's going to get the expertise. Richard, what's up next?
So there's a question that follows on a little bit to this discussion. Have there yet been any recent lower court decisions that in the months since Loper Bright was handed down have cited Loper Bright to overturn any federal regulation? Is this getting picked up by the lower courts at this point?
What do you think, Barbara? You want to handle that one?
Well, I have not done a canvassing of that, but I would just point out the glacial pace of judicial decision making. This was a June or July 2024 decision, and I don't think there has been time yet for cases to work their way to decisions that might cite the case. I'm sure it will be heavily cited. There's no question about that. I I think we need to see how it will be applied, and it's just 4 months later. Cases haven't worked their way through yet. I'd be interested to see what others think. I just think this is not yet long enough for it to have happened.
Anybody have a different opinion on that? Chris?
Yeah, and you can file this under that category for what it's worth. 2 weeks ago, roughly, I sat in on, actually a few webinars on this whole Loper Bright issue. And one of them was a webinar hosted by the EPA Alumni Association, which not too surprisingly contains a fair number of attorneys, some still practicing outside of EPA, but some not. Anyway, they invited a professor from University of Virginia and another one from Georgetown Law, and they opined as well. And I can't remember which of those two said it, but at the end, very end of the webinar, he said, "We've been tracking this. We looked at 38 cases since Loper Bright, and 70% of them have been impacted by the decision."
Mm-hmm.
Now, unfortunately, there was no reference, no URL, no, we're going to publish this fall. So again, for what it's worth.
Yeah, well, thanks. It's interesting. It gets to the point that was asked. Chris, I have another question for you. There were some scientists who registered for this webinar, and some other people who are developers of products. And, given our shared interest in engineered microbes for environmental release, let's just get to the brass tacks on this. Are there going to be unreviewed products flooding the market, released into environments? What do you think about that? And will enforcement activities decline at regulatory agencies? What do you think?
I'm glad you raised that, because that's one of the points I skipped over earlier. Yes, I absolutely think enforcement activities will decline. And part of that is, I have to say, in the last 20 years, roughly, at least at EPA, I can't speak for FDA or APHIS, but at EPA, basically since the George W. Bush administration, we've seen a decline in the number of people involved in enforcement, but also just activities. And I'm relating this to the biopesticides. I can't speak about oil spills from a cruise ship off the coast, that kind of thing. I don't know what's going on there. But I have a colleague, I had dinner with him last week. He's at Virginia Tech, and he used to work for the government. Now he's a adjunct faculty, but he still has grad students, very, very involved. And he sends me almost every month or two a label of an unregistered pesticidal product that's on the market. And he says, "Please funnel this to the right people at EPA." But yet he says, I can't find any evidence that anything ever got done. I can tell you my only real involvement, significant involvement in an enforcement case was one that I worked on the very first week I was at the agency. And someone told me a couple of years ago, I've been retired now for 3 years. They said, "Hey, we finally went and did the enforcement action 21 years later. wow, okay. So yeah, I think given the uncertainty, I don't think people are going to be putting as much money and resources into enforcement. That's one. But in addition, and actually, to my opinion, more interesting consideration is that I do believe some products that we currently regulate may no longer be regulated. For example, you may have seen the draft language in the Farm Bill regarding biostimulants. Now, back when I was involved with that, the folks who were on the industry side would tell you this could include genetically engineered bacteria, for example. And I have yet to see anything like that labeled that way. I know there is activity on Capitol Hill. How that will impact what EPA can regulate is obviously speculation at this point. But I think as one consultant said to me, I said, well, how do you define a biostimulant? She says, that's what we call it when we don't want EPA to regulate it. I said, okay, that's a good working definition. I appreciate your honesty. But yeah, I mean, and I don't mean to sound negative because I actually think in many ways it's a good thing. As you know from past diatribes of mine, I think that, you know, as soon as recombinant DNA is involved, the agencies tend to flip out over it. And I think, you know, we've done that. We've been there. All right. That was back in the 90s. We should be way beyond that now. That doesn't mean everything that's engineered doesn't get regulated, but don't regulate it beyond what you would do a naturally occurring, say, bacterium or fungus that you're going to put out in the field just because it either has a marker gene or whatever you put in there. You know, if it's a synthetic element that encodes an allergen, yeah, I get that. You want to be cautious. But beyond that, we really need to move forward, I think, as both a scientific, you know, society, but just the average consumer suffers from a lack of the progress that could be made if we had, I think, a more functional and less one of my colleagues wrote a chapter for a book I did on regulation some years ago, and I told him, I said, be honest. Just tell us what you think about your experience with USDA APHIS, with FDA, CIFSAM, with EPA. And being the gentleman as he said, EPA is the most administratively complex agency of any of the ones I had to deal with. And, you know, I think that's partly because of FIFRA and just the history of the agency. But I think it's a good time to follow APHIS BRS lead and start moving forward, looking for off-ramps for engineered microbes and things like that. And with that, I'll pass it to Keith.
Yeah, Barbara, if I may. I'm sorry, Mary, if I may. I wanted to kind of go back to the previous question. I agreed 100% with what Barbara said in terms of how long it takes for cases to work their way through the courts and the likelihood that there wouldn't be a specific impact on, you know, from Loper Bright quite so soon. So I was curious that, you know, Chris said that there was a presentation where someone said there were 38 cases that had been impacted by that. I'd be curious as to what that meant and, you know, how impacted was defined, because quite frankly, if you look at it from the standpoint of what the decision said, you could take a case where a court said, you know, we're looking at the way the agency interpreted the statute. We find the statutory provision to be ambiguous. We, in fact, will defer to the agency on the basis of Skidmore deference. Well, that case was impacted by Loper Bright because they didn't evaluate the case on the basis of Chevron deference, but rather Skidmore deference. An agency still could have deferred to the agency, but just on a different basis. I would assert that in fact would be an impact of Loper Bright. So we'll have to see what how this plays out. You asked a question. The second point, Mary, you asked a question about enforcement, and again, I don't see Loper Bright having an impact on enforcement activities because A, it's a prospective case, and B, it's talking about agency interpretation of a statute as opposed to agency implementation of enforcement mechanisms. But, and this is a huge but, all caps, what is in fact going to have an impact on agency enforcement is another case that was decided last term, which is the Jarkizi case, in which the court basically said, it was an SEC case, and the court basically said, if an administrative agency in an administrative enforcement case seeks monetary penalties for violation of a regulation, that case has to be brought in a federal court. It can't be brought as a case in the agency's home court of their administrative law judges. And I think that's going to have a huge impact. I have, over the years, I've been practicing now for over 35 years. Over the years, I have always advised my clients, if in fact there's a possibility of an enforcement action, we are going to move heaven and earth to settle that action. We are not going to go before an ALJ because, A, you don't want to spend the money that you're going to have to spend for me to defend you, when in fact I can give you pretty reasonably confident assurance we're going to lose, because that's what happens before ALJs. You lose. So you are better off settling with the agency before you go into that rigged game. And so what the court has said, and I think if you go back and you read the case, I mean, the court actually cited the fact that very rarely does the agency, or did the agency lose, whatever agency you're talking about, very rarely did the administrative agency lose in cases before ALJs. And so now if you're an agency and you are going to seek penalties, monetary penalties against a perceived scofflaw, and now you have to go into federal court, well, that's a very, very different calculation for that agency than going before an ALJ. So I think that case will have a much greater impact on agency enforcement activities than Loper Bright will. And I'll stop there.
Thank you, Keith. This is such a great conversation. Richard, I see things are flying around in the Q&A. What do you think?
Great. Why don't we got a question about what particular classes of biotechnology products have not yet been challenged and thus are not subject to stare decisis, and therefore, in the panelists' opinions, might be subject to future challenges. And maybe, Sarah, I know you've thought a lot about, kind of horizon scanning and future products. I mean, if you just say, what do you think are the ones that we might think about, and we can toss it to others as well.
Yeah, well, certainly there's, part of the biggest challenge with this stuff is being forward-looking, and but one thing that was just occurring to me about these like regulatory rulemaking, Chris, multiple people have made this point about how long it takes to make an actual regulatory rule, and how increasingly even in the past several years, the agencies rely more and more on guidance, and and these guidance documents, which are not, I've learned recently, subject to Chevron, as Barbara was just saying, and it's possible that in the future, more and more things will be subject to that kind of a guidance document instead of the full regulatory rulemaking. So in some ways, the question is not just about what over the past 30 years, which things have already gone through that fire to become established as real established legally bits of parts of the coordinated framework, but where are we going to need pieces like that in the future, or can we just go entirely to guidance? It's not clear to me where there's going to need to be those newer rules as actual regulatory rulemaking instead of just guidance and things like that. So I think that there is I don't know. I don't know what to think about that. And I'd certainly there's also a actual legal research question in here that I do not have the answer to. That I'm hoping others will. The last thing I'll say about it is just that I know that when way back in the day when I first came to Washington, I was a AAAS fellow, And I was at the EPA at that time, and I remember talking to some of the legal folks there, and they somebody said, well, whenever we put out a new rule, we get sued from all sides, and that's how we know we're doing the right thing. It all just gets tempered that way. And I was just thinking through that. It's possible that many of the parts of the coordinated framework have already had that kind of court decision making that makes it sort of safe from reopening. At least I guess I can hope that. But yes, I would prefer for somebody with an actual legal background to weigh in on this question.
Yeah, open to anybody who wants to weigh in on that. Thank you, Sarah. Yeah, over to you, Barbara.
Well, I agree very much with what Sarah was saying about, it's a really complex issue when an agency is going to make policy, what instrument it chooses to use. Does it do a rulemaking and do that whole process, or does it do a less formal policy statement or an interpretive rule or a guidance? And I have turned in my head whether Loper Bright will affect that choice very much. It seemingly would. If you go through all the work and pain of doing a rulemaking, then you would, under Chevron, get a deference that you don't have the other way. However, I don't think that has been the key factor agencies look at when they decide whether to issue a guidance or do a rulemaking. One is the exigency of time. If you need to address an emerging policy concern quickly, guidance is faster. And the other thing, and it's kind of a ironic thing that isn't widely understood, a guidance document is actually harder to challenge in court than a regulation is, because our framework of judicial review requires someone who wants to challenge an agency policy has to show standing, which means they have to prove they've had an injury as a result of what the agency did. And then it needs to be a final agency action that they're challenging. And the problem with a guidance document is that if you try to challenge it, the agency can say, oh, no, that was just preliminary thoughts. It wasn't our final word on this. And then you can't challenge it. And in the same way, it's really hard to show you're injured by a guidance. The agency says it's non-binding. You don't have to follow it. So we are in a time when guidance is used partly because it is so hard to challenge. If you can ever get into court, the erroneous guidance, if it's erroneous, won't get much deference, or it'll get Skidmore deference only. But it's really, really hard to get a guidance challenge into court. So I have not been able to come down on one side or the other whether the loss of Chevron deference after Loper makes any impact on an agency's thinking when it's deciding how to announce its policy. I'd love to get the other people's opinion. You've worked in regulatory agencies and may know more than I do about how they make that calculation.
And it looks like Keith has volunteered to take you up on that.
Yeah, I agree with Barbara on that in that respect. Agencies are very smart in terms of how they approach guidance. At the end of the day, guidance, the agencies always say guidance are not binding because they're not binding, because they haven't gone through notice and comment rulemaking. A regulation has gone through notice and comment rulemaking. It has the force of law. A guidance which has not doesn't, and it's not binding. And so unless an agency actually makes a determination and impacts a party in a manner that party feels they have been injured, and the agency explicitly bases its actions on its guidance, then the party can't sue on the basis of that guidance. If the agency is so stupid as to do that, then yes, you can go into court and the agency will probably, not have a snowball's chance of prevailing if they in fact have relied on non-binding guidance that was not promulgated through rulemaking. But, agencies just don't do that.
Okay, well, oh, there goes Chris. He's taken off. So he knew I was going to ask him a really hard question. Uh, so one of the things that I think we want to turn back to is self-regulation by professional societies. This was a really early question that has been sitting there, and I'm wondering, does anybody want to take a swing at this?
Kind of a little bit like, right, sort of the guidance part, right? But now by industry instead. So yeah, Sarah, maybe yes.
Self-regulation is a crucial component of our overall system for setting norms around many things that turn on scientific evidence. For example, the clinical practice of medicine has a framework of laws, but when it comes right down to it, a lot of the issues are determined by professional consensus, and law defers to it. So I deal with this issue of self-regulation in a different context. I work with information technologies, and governmental regulation of information technology can touch upon some First Amendment issues pretty quickly, because when the government starts saying that certain information is safe or unsafe, it's engaging in content-based regulation of speech. And one of the ways to avoid that is to empower professional societies and private sector entities to set norms, and they are not subject to the same constraints on regulating speech. An example would be that IEEE or a society of medical professionals could make determinations that certain information sources are not safe, and that wouldn't implicate the First Amendment. So I think as our technologies move along, we need to be thinking in the way the questioner was, that there is a crucial role here to play by engaging the professions and technical societies, because the private ordering solutions that come from non-governmental entities sometimes get more buy-in, sometimes have more, they avoid some of the legal issues that constrain what agencies can do. So that we mustn't forget that. We mustn't say, oh, we need regulators to do everything. Regulators play a crucial part here, but they can't do it all. I would love to hear Sarah's thoughts on this, because I know she thinks about these things a lot.
Yeah, well, there are a lot of different frameworks that are voluntary, and I too work in sort of adjacent areas where there are voluntary frameworks. And in my case, I work on biosecurity, and among DNA providers, these big commercial companies, they have voluntarily decided that they will screen customers and screen the ordered DNA to make sure pathogen and toxin DNA isn't misused by somebody without a legitimate use for it. And it was a voluntary framework for many years that best practices were developed. This is something where the industry saw that it was in their own best interest to do this well. And I think there are a lot of parallels here. I think that there are interests within the industry in a lot of corners that they like to have some kind of regulatory process, so they can show that they're doing the right thing, especially when biotech products can be the public sort of discourse about it is so complex, and the regulatory system, does give them a little, stamp of approval. But I think if there were, other ways to get that kind of stamp, I think that it would be, an effective thing to do. The last thing I'll say is that I've seen this in action where there's interest in some of these things. I went to the last couple of years at SynBioBeta. I've participated in discussions about voluntary systems of oversight for genetically engineered microbes primarily. But there, there's a lot of interest among those small startups that are trying to figure out where their stuff fits in and what types of regulations they fall under. And if there aren't the regulations that, especially pre-market regulatory processes, they want to make sure that they do it right, that they're being responsible. And there's a lot of interest in trying to generate best practices and trying to establish some sort of industry code of conduct about those sorts of things. And I think there's a lot of promise in that kind of framework.
And if I can come back in on that, one of the, I'm generally a supporter of a coordinated framework approach that you use the existing regulatory agencies and have them work within their authorities. It has worked fairly well over the past 40 years. But one of the problems with using your legacy regulatory agencies is their jurisdiction is siloed in ways that made sense 50 years ago or 100 years ago. That one regulator did this and another regulator did that. And as technologies evolve, that siloing sometimes doesn't leave anybody with a full set of authorities to deal with the complexity of things. And that's where, given, I think, the reluctance of all modern nations to create huge new regulatory bureaucracies, filling those gaps is a really crucial thing and needs to be done by someone. I'll hand it back to Sarah now.
Yeah, just another quick point on this topic is that you mentioned the jurisdictions, and when you have these more voluntary, these sort of best practices based approaches, they can reach, those can be established internationally. They can be established across, different groups about whatever kind of community that you find. That is common by technology or whatever kind of interest. And then once you've started to establish some types of best practices, those can be incentivized in different places in different ways. In the US, we might have guidance or funding requirements or, regulatory policy. And in another country, they could do what whatever works for them. And it's the incentive building that makes more sense in those different kinds of jurisdictions. Whereas the practices can be, a little bit more more fluid and a little bit more, specific to technology or specific to a community.
Barbara, if I may follow up on something, I heard you say that no agency, that there are silos, jurisdictional silos. Nobody has the full set of tools to handle the complexities. I remember this was the theme of that report that you worked on. And right now, there is a congressional advisory commission thinking about issues related to the emerging biotechnology. You made the point that filling those gaps is important. What, if anything, would you be willing to say should be done right now if you are going to provide advice to Congress?
Yeah. I would stress that the notion, and I do best with examples from medical technology instead of environmental technologies, just because that's what I work with. The way we siloed things is we have FDA to determine if medical products and things are safe and effective. And then we have medical practice regulators and clinical laboratory regulators to look at the process that uses the things. And what gets lost there is that if you try to make things safe in a piecemeal way, for example, we're going to add one more alert onto this device to alert the physician to be careful, you add to the complexity of it. And I keep going back to some of the work. He was a sociologist at Yale, Charles Perrow did. He did studies in the 90s looking at large, high-risk technology accidents, things like chemical plant explosions, nuclear accidents. And he said the key thing isn't whether each component is safe. You've got to look holistically at systems. And the thing that makes accidents inevitable is the sheer complexity and the tight coupling within these systems that if one thing fails, there may not be time to intervene before it induces another failure. And my main concern with our 20th century regulations is they're not looking at things holistically, and we have different regulators intervening in a piecemeal way to make the doctor safer or to make the device safer. But not looking at the key things that make accidents happen. And that's that these things are happening so fast beyond the speed human operators can analyze the fault as it happens. And we've got to take a systems approach. So my advice to Congress would be that the complexity of the technologies that we're facing now, and I'm talking about medical AI, financial AI systems, engineered microbes, we really need to, at this point, take a hard look at whether the notions of safety and effectiveness that we relied on in the 20th century are up to the task. And we may need to leverage our human regulators with more information systems to help them keep pace with things and do the surveillance on a continuous basis to determine when faults are starting to hurt people and intervene quickly. So I'm about at the point that I think we've played out using these old regulations and need to take a more expansive view of how do we make the current technologies safe.
Thank you, Barbara, for that helpful comment. Keith, really quickly, do you have a follow-on before we get to the last few questions?
Yeah, I do. And as you know, as many people know, I, for many years, have been very critical of the coordinated framework because of its uncoordinated nature and the fact that it is siloed and the fact that, you know, you have the regulators, and it's not by the fault of the regulators. I mean, the regulators are doing what they have to do. The lawyers at FDA tell them what their statutory responsibility jurisdiction is and how they must act. The lawyers at USDA do the same thing. The lawyers at EPA do the same thing. And so there is no actual coordination, and there can't be because of the statutory differences. What would make a difference is if Congress would actually implement a true coordinated framework from a statutory standpoint and empower the agencies to operate in this manner. But is that likely to happen? Of course it's not. And one suggestion that I would have, one very strong recommendation that I would have for Congress is to bring back the Office of Technology Assessment. Sarah, I am a fellow, AAAS EPA fellow. My year was 1991, and during that time, I actually worked with a gentleman who came from California as a AAAS fellow, liked DC so much he stayed on at OTA. And that was 1991. He worked at OTA, and in 1996, you know, under the Contract for America, you know, we're going to, you know, kind of do what we can to make America a less successful society. You know, Congress did away with OTA. And, you know, at a time when society, when life in general is becoming more and more technologically complex, I think it would be very helpful for science, for Congress to actually have a body that can speak to these very complex technologies and help to advise them on, you know, the different options that are available and the different considerations that they should be taking into account.
That's a very clear point. Sarah, do you want to add anything on that and before we move on?
No. Yeah, the OTA, you know, I always love every reference to OTA. I'm too young to have experienced OTA, but I've heard from many people about its value. And it does seem like one way that Congress should, should be able to get the kind of information it's going to need. Now, not just on the coordinated framework in biotech, but a huge range of technological issues that they seem right now ill-prepared to handle.
All right, thanks. Okay, Richard.
Great. We got a couple of questions
next?
left. Yeah, I hope we can get to both of them. So the first one is, in general, agencies regulate based on what the substance is and its intended use, which helps determine regulatory triggers. Is that operating principle likely to be impacted by Loper Bright? Barbara says no.
No, the regulatory jurisdiction agencies comes from these statutes that Congress passes, and Congress has defined many agencies' jurisdiction in terms of things or substances. FDA can regulate something that meets the definition of a device. EPA can regulate things that meet the definition of a pesticide. That's set by Congress, and Loper Bright is not going to tamper with statutes. It's tampering with how agencies interpret the statutes. So my sense is the fact that we do have this sort of substance or thing-based definition of jurisdictions, that's a historical thing that just reflects the way Congress defined jurisdiction. Chris, can you jump in?
Yeah, I generally agree with you, but I think there are important exceptions. One I mentioned earlier, specifically with pesticides. The definition in the statute in FIFRA is written by Congress, but the interpretation of what a substance is was carried, in some people's estimation, too far by the agency policy wonks. And so, I won't be surprised if the next year we see some challenge and somebody says, that Bacillus thuringiensis you want to spray in your garden, it's not a pesticide because it's not a substance. It's a living organism. And, at least people, I think, will try that because it would really, change the landscape. Is the best way to put it.
Fantastic. Thanks to both of you for different opinions on that. And with Keith as a critic of the coordinated framework and Barbara as a supporter of the coordinated framework, we got all these perspectives. Oh, the hands are going up. Okay, Keith, over to you.
Yeah, just very quickly following up on what Chris said, I will point out that EPA, in fact, promulgated a rule last year in which they addressed molecular biological techniques in which a technology developer developed a knockout. And so the function of that knockout was, in fact, to not produce a substance. And EPA took the position.
Sorry, Keith. A knockout in this case is a term for taking out or disabling a gene that then results in a minus, if you will, not an add back in, but a minus of a gene. Is that correct?
Yes, thank you very much, Mary. You said you were going to do that, and I appreciate you doing that. Yes, because I did fall into jargon, and yeah, for those who don't understand it, Mary was exactly correct, and that's exactly what I meant. So you knock out a gene, and rather than produce a pesticidal substance, the knockout influences the plant's growth, development physiology by not producing a substance. And EPA has taken the position that the altered gene is a pesticidal substance that they have regulatory authority over, even though what that altered gene is doing is not producing a substance. And so that gets to Chris's point. I actually, to be honest with you, I had a client who came to me and asked me for an evaluation of whether or not they should challenge that. And I told them, it's very topical. I actually told them that under Chevron, I thought that the agency would get deference on that interpretation. I disagreed with it, but I thought they would get deference, and I told them I don't think it's worth your money to try to challenge it. With Loper Bright, maybe there's a different approach.
Thank you, Keith. Any other comments on this before we move to the final question? Okay,
Great.
Over to you, Richard.
Great. Okay, so the last question is, what impact could Loper Bright have on international cooperation in biotech products? And Sarah, of course, mentioned a little bit about looking at other countries and what they're doing, but here I think maybe specifically on, cooperation on biotech products and the role of Loper Bright in that.
Yeah, what do you think, Sarah? You want to expound on that?
No, it's hard for me to tell. I mean, well, first of all, I don't have Chris's, the crystal ball that Chris has mentioned that none of us have. I think that it might be a little bit too far out for me to really opine about it. I do get the sense, though, that the agencies, a lot of the cooperation, among the surrounding biotech regulation does happen at kind of an expert to expert level, and I don't see that would impact it very much. But I'm not, I'm not as well versed in the more official, trade negotiations and all of the, like big, agricultural, stakeholders and those sorts of things. So if others have a more informed opinion about that, I would be interested.
I can see how something would potentially affect the willingness of entities in other countries to cooperate with American businesses and academia if they thought Loper Bright had made things less stable, so that the US regulatory framework is now more likely to flip around a lot and change as a result of this. But as I mentioned, the empirical data show that Chevron deference was not being very widely and rigorously applied even before Loper Bright. The practice was that courts were using a very complex continuum of multiple deference approaches depending on things. And so I am skeptical that this is going to change the stability of our regulations across the board. I agree with Keith and Chris that there may be certain interpretations that now could be challenged, but I don't think it will, as a whole, make the American regulatory framework seem less stable and continuous than it did when viewed from the outside. So I suspect international actors are more concerned about the substance of what the regulations say than the procedures that our courts would use in reviewing them. So I don't think it will have a large effect, but this is all speculation. We don't know what this is going to look like 5 years from now.
And here comes Chris with his crystal ball.
Yes, I finally unpacked it while we were talking. Now, I tend to agree with what Barbara said. My one real concern is, and it's somewhat tangentially related to, cooperating with a foreign researcher on some product. But my concern is that if the journalists who report on this don't do so in a very careful and exacting way, people in other countries could come, and even in this country, could come away with that misinformation saying, oh, well, now the courts are going to do the review. EPA, USDA, FDA, they're not really weighing in on this. And these courts people, they're not really scientists. So I'm losing a little faith in those ag commodities that we're importing from the United States. And that is my biggest fear because, as you know, from other minor incidents in biotech where, there was some LL601 rice or Starlink corn or whatever, they're billion-dollar impacts, and they go on for years just because somebody thought it might be an issue. And that's my concern, is that it isn't handled well in an information sense.
All right. Any final words on international prognostication? Going once, going twice, and we are right on time for us to try to do a little summary here, Richard. I think there's a range of differing opinions as to whether Loper Bright is going to have a significant impact on future products of biotechnology. Seems like maybe not. The crystal ball comes into play here. Some themes that I heard, and then I welcome you, Richard, to jump in. Concepts of judicial activism from Keith that I think was really something to think about. And from Barbara, I heard this idea of confirmation to practice. That's just what this is. It's conforming to what entities are already doing anyway. The idea of the role of self-regulation by communities of practice and by professional societies and industry. Sarah had a nice piece on how this is already happening and some examples of that that may come into play. And of course, the big picture here on agency rulemaking and guidance and what instruments are, if any, will be affected by this Loper Bright decision. I think along with that comes this agency enforcement question that Chris brought to us. And so there's a lot of themes here that I heard. I didn't hear top of the list. These are the next biotechnologies that we need to, that we expect will be affected by this. So I think those are some overarching themes from me. Richard, what do you think?
Yeah, well, I think it's very interesting. I think one of the things that came across to me in this discussion is we're going to have to see how things play out, right? I mean, this is, as cases come up, right, as new laws get written and other things, I think it'd be very interesting to see how Congress reacts to Loper Bright and what they do in legislation that might come up related to biotechnology and whether they do things differently than before in terms of being more specific about, the power that the agencies have in interpreting it by saying that somehow. So I think that'll be very interesting to see. So anyway, I think there's a lot of interest around this. And I think, I hope everybody in the biotechnology community will be, kind of thinking about, what ought we be doing as citizens, right, as we think about how all this plays through.
Yeah, well, I think it's time now then to think about the thank yous. And first and foremost, I want to say thank you to the panelists for sharing their thoughts and their time and for agreeing to do this. I know it came up together pretty fast. And aside from a couple little technical hitches, I think this was really fantastic. Thank you very much for making the commitment to do this. And a thanks to the audience, not only for joining, but also providing some really interesting questions. I'm going to have to go look up Corner Post. I didn't do that in my homework. So thanks to the audience members for questions. Richard, thank you for co-organizing this and for handling all the questions today and generally being really great in adaptive management on stuff. And I want to say thanks to Sabrina Hameister for all of the technical support that she gave us in making this happen. And then, of course, to the Linde Center for basically saying this is something that's really important to us and we want to have a webinar on this. Before I turn back to Richard to close this out, I just want to mention that the National Academies of Sciences, Engineering, and Medicine has announced recently that it will be holding a related workshop entitled Implications of Recent Supreme Court Decisions for Agency Decision-Making. And my understanding is there's not a date set on that yet, but it'll happen early in 2025, and they expect to follow up with a written report. So you can probably hear a lot more about Corner Post and Skidmore and all sorts of our favorite terms now from previous decisions. And with that, back to you, Richard.
Great. Well, first, I'd like to thank, again, Mary and Barbara and Chris and Keith and Sarah for participating in this. We really appreciate your time and all of your insights. It's been fascinating. To all of the attendees for your participation and questions. Again, if you're interested, you can find more information on the Linde Policy Center website and sign up for our mailing list if you'd like to, kind of hear about future activities that we're organizing. So with that, we'll go ahead and close 15 seconds after noon here on the West Coast. So great timing, everybody. And thank you. And as people are logging off, just for the panelists, just so you know, when Sabrina ends the webinar, we all disappear too. So thank you all. And it's been a pleasure having you here today. Thanks, everybody.